So one of the things that, these are the protections with Homestead that are so fantastic here in Florida as opposed to other states. And like I said, every state is different on this. Under our Constitution, we have certain things that if we have a homesteaded property, you can't just take it away. You just can't give it away. So one of them is restriction on alienating the homestead without spousal joinder. And we'll talk about each of these too. Restriction on devising the homestead by will, an exemption from forced sale of the homestead to pay debts, aka bankruptcy, and a partial exemption from taxation. So with homestead, you can't sell a property without joinder of spouse or mortgage it. You can't will or devise your property to someone other than your spouse under a will. If you go into bankruptcy and you file the property exemptions, they can't take your property away, your homestead property. And then we also have that homestead tax exemption. So let's talk about each of these individually. The owner of homestead real estate joined by the spouse if married may alienate the homestead by mortgage, sale, or gift. What does that mean? It means that the owner of homestead is only able to convey or mortgage homestead property if his or her spouse also signs a deed of mortgage. Otherwise, the conveyance is prohibited. When you get married, your spouse, so if let's say I get married, I'm a single, I get married, I own the house right now as a single woman, I get married. It's my homestead. My husband moves in, hopefully, he lives with me on our homestead. I'm like, well, I'm going to sell this property. He needs to now sign off on it because we are married, even though he's not entitled to the property. I cannot unilaterally get rid of his homestead, even though he's not entitled to it. He has a protected interest in it. That's what this is talking about. And that's important for you as a realtor, because this is where Chris and his group are going to be like, hey, where's the spouse they need to sign? And you're like, oh, but they're not entitled. Doesn't matter. If it's homestead, we need that joinder of spouse. One of the things, we get up questions a lot, and this is the worst thing about the joinder of spouse piece, is we do our title search, right? And we'll find the last deed of record shows Bob Smith, the single man, bought the property. We can get all the way to closing. And if Bob Smith doesn't disclose he has a wife, we won't know. Eventually it slips that Bob, he's like, oh, my wife, blah, blah, blah. And we're like, hold on, we stopped the closing. We've got to go get his wife to be able to sign off on things. That's the constitutional protection. We're not being difficult in the title world. We have to do it. If we do not, the spouse doesn't sign off on it, we have major issues because we've now basically violated the Constitution. So you as a realtor, if you're taking a listing, first question you want to ask is like, oh, are you married? I mean, you can be, flower it up or whatever. I'm a very direct person. So I'm like, are you married or not? Because that's going to be really important, because you don't have to switch your title to a married man. It'll be a single man until we find out that you're married, and that spouse has to sign off on it. And we will get into fights with homeowners that are like, well, they're not on title. Doesn't matter. Here's the constitutional protection. Another thing with marriage, which I say in every single class I think I teach, is you're either married or you're not in Florida. There's no, oops, I jumped ahead. There's no, I'm in the process of getting divorced. We're going to get married. We're legally separated. There is no legal separation here in Florida. So married or not, if you are married, then your spouse has to sign off on the document. That's it. There is no way around it, except for a homestead waiver. So effective July 1st, a spouse can waive his or her interest in the homestead with respects to devising it, to deeding it, and things like that. Specific language has to be on the deed, though. By executing and joining this deed, I intend to waive homestead rights that would otherwise prevent my spouse from devising the homestead property described in this deed to someone other than me. We also see homestead waivers in like prenuptials and postnuptials, and we may take those, depends. whoever is signing that or whoever's agreeing to that really needs to understand what their homestead rights are. They really need to talk to an attorney. So if you have parties that are looking to do a deed, something like this, where and someone's giving up their homestead rights, they really should be talking to counsel so that they fully understand what they're giving up. Because once they do that, it's not even having to do with like being able to sell the property. We're talking about wills, which we'll get to as well. So we want to protect that person. Separated spouses, we don't have that legal status here in Florida. There is no legal separation. You're married or you're not. It's black and white. There is no other caveat. There is no, I haven't seen my husband in 20 years. You're still married under the eyes of Florida law. There's no statute of limitations on that. Or she's in prison. Well, we send mobile notaries to prison. Doesn't matter. Doesn't matter if they ran off to Colombia. Doesn't matter if they ran off to Antarctica. We can send a mobile notary and find them, get them. Or you go to court and get a dissolution of marriage. End of story. You may, as a realtor, get, and this comes up a lot, I know with realtors, as you're taking a listing and they're like, oh, no, I'm in the process of getting a divorce. I'm getting the property. She doesn't need to sign. Yes, she does, until there is that final decree of marriage because of that homestead protection. You're married or you're not. That's the end of the story. Write that down in big, bold letters, because if someone comes back to you and says they don't need to sign, you can say, well, you can either send them Chris's group, or you can say they have homestead protections under the Florida Constitution. And that's pretty much it. So general rule, married or not. So the first one, huge protection, joinder of spouse. So that just means the spouse has to know what you're doing with the homestead property, even though they're not entitled to it on like a deed. They have a right to the property under the Florida Constitution. There's also probate, homestead rules and probate, and that also falls under the constitutional protections, where it says the homestead shall not be subject to devise if the owner is survived by spouse or minor child, except the homestead may be devised to the owner's spouse if there be no minor child. We're not going to really worry about the minor child piece right now, because that's a whole probate class I do, talks about guardian ad litem. We're at this point, let's just focus on the fact that if you own a property and it's your homestead, and I'm a married woman and it's my homestead and my husband lives there, and in my will, I'm leaving this homesteaded property to someone other than my spouse, that is a violation of the Constitution. Once again, if you're preparing, looking to create a will, please go talk to an estate planning attorney that works here in Florida that understands the Florida Constitution. Because if you try to devise your property, homestead property, to someone other than your surviving spouse, the Constitution or the Florida state statutes actually takes that property out of your will, and now it's a standalone property. And what happens is the surviving spouse is going to get the property anyway. They'll get a life estate in the property. The remainder goes to any lineal descendants like children, etc. So there's no way of getting around it, because Florida's like, you're married or you're not. If you're married, spousal protection. That's your homestead protection. So you cannot unilaterally just will your property to someone else. Your investment properties, you can do whatever you want with. It's homestead. And we see a lot of, not a lot, but we do see contested wills where people are, well, wasn't the homestead, I get the property. And then we have to go to court and have them tell us what's homestead or not. Because once again, on the title insurance side, we're insuring that this, everything's on the up and up. And if we get an issue, we have a claim, and we don't want to violate the Constitution. Doesn't look good for any of us. How do we know if it's homestead? For probate, we'll look at homestead tax exemption status on the property. If it's the last residence on the death certificate or the petition for administration for the probate estate. Otherwise, it's an order determining homestead from the probate court. And we do have situations where we do have to go back to probate and court and have them tell us if it's homestead or not. With anything with probate, just to let you know, we are really particular about it, because trying to avoid claims, errors come out of the woodwork, and especially when we're talking about homestead property and spousal rights. Homesteads and trusts. So A trust can have a homestead, as we know, but this is in regards to trying to avoid probate. People create trusts. There are revocable trusts, there's irrevocable trusts. Once again, please go seek legal counsel if you want to create a trust. You can pull out all these documents off the internet, right, and create your own thing, but it's, you know, there's specific rules for the state of Florida what those generic docs aren't covering. So you really want to talk to somebody, because if you put your property in revocable trust, and much like a will, you put your homestead property in revocable trust, but in the trust it's left to someone other than your spouse, you're once again violating the Constitution, and that property is taken out of the trust in most cases. So you need to be really conscientious of that, and you want to work with an attorney that understands that. There's no way, just let's put it this way, there's no way that your spouse isn't going to get the property. Even though you're like, it's in my will differently, or it's in my trust differently. The third protection is the homestead and bankruptcy. And we have here in Florida, I just did a bankruptcy class yesterday, and we really have like the best protection of homestead out of every state in terms of bankruptcy. So you file for bankruptcy, and you can, there's, you know, you fill out all your forms. Once again, please talk to an attorney if you're going through bankruptcy, because if you don't fill out the proper forms and you don't exempt, you don't put the Schedule C for the exempted property, your homestead, on it, you're out of luck. So under the bankruptcy rules in Florida, you can exempt your homestead property. There are some rules to it though, and that's all under the Florida court rules of when you can file. Back in the day, people would actually move to Florida because our protections are so amazing, because it's basically untouchable, your homestead property. Move to Florida knowing they were going to file bankruptcy or going to go into bankruptcy, buy a huge house here, claim their homestead exemption, file, you know, bankruptcy wherever, and that property was untouchable. And so they could sink a bunch of money into that house for equity or whatever, and it would not be touched by the bankruptcy court. Actually, O.J. Simpson did that. So when he did that, and they saw other bankruptcy court saw other people doing that, they're like, okay, we need to change the rules, and now we have requirements on how long you have to have lived here, how long have you had to own the property before you can file bankruptcy in Florida. So the general rule is you have to have at least lived here 730 days before filing the bankruptcy petition. That's 2 years. If you didn't live here within those 2 years, you're going to file bankruptcy in the state that you lived in prior. So let's say I moved from Georgia to Florida a year and a half ago. I'm trying to claim my Florida homestead property. I can't. It's got to go under the Georgia rules and whatever the Georgia homestead rules are. So that's one of the sort of protections really for Florida citizens as well. But note that, you know, if you don't meet these requirements, you're not going to get the homestead protections under Florida. And same thing, it has to be a half acre, 160 acres elsewhere. And before claiming the homestead exemption, you must have owned the property for at least 1,215 days before the bankruptcy filing. That homestead exemption as per the bankruptcy filings. And if you can't meet any of the requirements for the homestead exemption under bankruptcy, then you fall within the federal cap, and it's capped at $160,000, $375. So what that means is, let's say you own a $300,000 house, you do not qualify for the Florida homestead exemption. Only $160,375 is protected from creditors in a bankruptcy proceeding. The rest of it, 139, whatever, can be attacked by the creditors, essentially. So just know, once again, homestead in Florida, your spouse can't be ignored. They're going to have major protections, but you also get major protection under the bankruptcy rules here in Florida. Then, of course, we have the homestead tax exemption. And this is the fourth part of the protections that we have in Florida. And every homestead tax exemption is different in every state. Florida, we've got a pretty decent exemption. So what does it do? It reduces the value of a home for assessment of property taxes by $50,000, and it limits increases in the assessed value of a home to the lesser of 3% or the rate of inflation, the CPI, the Consumer Price Index. So let's take a look at the money aspect. So for the first $50,000 in assessed value of your home, up to $25,000 is exempt. And I have a little graph that makes it a lot clearer. The exemption applies to all your property taxes, including school district. You pay your full taxes on the value between $25,000 and $50,000. And then any assessed value between $50,000 and $75,000, you get an additional $25,000 exemption, but school taxes are not exempt from that. Above $75,000, you pay the full tax. So let's just take a little look at this graph. If you look at a $90,000 house, you can see the first $25,000 fully exempt, second $25,000 taxed, third $25,000 exempt except school taxes, and then the final $15,000 is fully taxed. So you get an idea. Basically, you get $50,000 in savings on the taxes.